A very warm welcome, good morning to all the participants, all our law students, aspirants, legal practitioners, senior advocates who joined us today from different regions of Maharashtra for today's exciting Sunday Law Bulletin session. It's a great pleasure to have each one of you with us here today. And for all the newbies, here's a brief introduction about Lawyers Development Forum. As we all know, Sunday Law Bulletin session is a signature initiative of Lawyers Development Forum, and popularly known as LDF. It's a vibrant platform which is committed to nurturing growth, learning, and camaraderie within the legal community. LDF not only inspires interest in the field of law for all legal practitioners, but it also brings together advocates through a blend of academic excellence and different activities that fosters recreational spirit too. Now, from insightful lecture series to energizing sports events like cricket matches and badminton tournaments, this forum fosters both professional and an overall development amongst the advocates. LDF also actively hosts conferences featuring esteemed judges and expert speakers, creating opportunities for meaningful guidance and practical learning. And of course, our weekly Sunday Law Bulletin, as you all know, is a signature initiative where specialists and experts from different domains come together and they break down the complex topics and encourage deeper engagement within law. Now, for this particular endeavor, we are deeply grateful for the pillars of this forum: Advocate Dr. Rajendra Anbhule sir, Founder President LDF; Advocate Vijay Shelar sir, Secretary LDF; Advocate Abhishek Arvind Jagtap sir, President LDF, for their vision and dedication that continues to still shape and strengthen this forum. With that, let us now quickly walk through our program schedule for today. We have with us a prominent personality. It's an honor and privilege to introduce our esteemed guest speaker for today, Senior Advocate Anil Tulsiram Tambe sir. Advocate Tambe sir holds a BCom degree from Anna Sahib Magar College, and he also has a strong foundation in business and finance thereby. He further pursued his LLB from the prestigious ILS Law College. Now, demonstrating his commitment to specialized legal education, it stems from his diploma in LLM, labor laws and labor welfare from Symbiosis College the same year. Now, this equipped him in in-depth knowledge of labor jurisprudence and industrial relations. He's been practicing as an advocate at the Pune District Court since 1993, bringing over 3 decades of rich experience in civil and revenue law. In 2000, he co-founded Rao Tambe Associates, a successful partnership that served clients for nearly 17 years. Now, since 2017, he has been independently leading Advocate Anil Tambe and Associates, a modern technology-driven law firm supported by well-equipped legal library and a dedicated chamber in Pune District Court. He was a founding. He's also adding to his legacy. Law runs in his family. His wife, son, daughter-in-law, and nephew are all a part of the legal profession. And together with a dedicated team of over 20 professionals, they continue to provide comprehensive legal services. Beyond practice, Senior Advocate Tambe sir is also passionate about legal education. During COVID-19 pandemic, he initiated an online webinar lecture series for budding lawyers, sharing practical insights and knowledge that continues to benefit the legal community through recordings available on YouTube. Sir, your remarkable journey of professional excellence, expertise, leadership is truly inspiring. It's a great pleasure and honor to have you with us here today. On behalf of LTF, we extend our heartfelt welcome and gratitude. We now respectfully hand over the mic to you, sir, and eagerly look forward to your enlightening session. Thank you so much, sir, for being present here today.
Thank you, ma'am.
Thank you.
Thank you, Abhishek. Thank you, Ashish, and all LDF team for inviting me and giving an opportunity to deliver a lecture on conveyancing. See, I will not define the definitions of the conveyancing things. I would like to say that the conveyancing is, though apparently find it is very easy and very simple job, but it is to those people who are having a copy, cut, paste, draft. In fact, the conveyancing is a great task, and while making a conveyance of any particular transfer of title, transfer of property to from one person to another person, or one legal entity to another legal entity, or vice versa, or inter vice, I would like to say all young budding lawyer and even those who are in the field for so many years, the conveyancing part of transfer of property is not just making a draft and getting it registered. I would like to say that unless and until you have the very expertise, means tracing of title of the property since minimum at least 30 years. Why it is 30 years? Because it is not a logic behind it. It is a legal aspect that 30 years It connotes to a limitation act under the Limitation Act of 1963. The Limitation Act says that any property which is mortgage and the person, the mortgager, has a right to redeem the property within the 30 years. So why the 30 years search title is being procured is one logic. Another is a 13 years we required in the title report. Why it is 13 years? Because you all are aware that under the Limitation Act also, the adverse possession is claimed when for continuous, uninterrupted, openly, passively possession is more than 12 years, you can claim the ownership by way of adverse possession. So basically, the flow of title, investigation of a title is much and more important while drafting any type of conveyance. Let us take a case that sale deed, agreement to sale, mortgage, gift deed, exchange deed, lease deed, whatever nomenclature of a document you find to do that. The flow of title is most important and paramount while you are dealing with such type of transfer of properties. Now, conveyance, now we have in a recent time, or it is a long legacy that the initial in an orthodox period, the drafting was done by the bond writers. They were allowed with the license from the government authority, and the legal fraternity was quite away from the drafting of the conveyancing. Apart from the big solicitor firms or solicitors, they are used to work for the corporate sectors, big industrialists and other entities, and those who are having huge investment in the real estate market, the builders. Nowadays, advocate equally are doing the great job of making conveyances. They have their great practice in the conveyancing field, because those who are not going to the court, but still they are making conveyance. But I really request to all the budding lawyers, all the lawyers who are upcoming lawyers, new lawyers, don't go directly to the sub-registrar's office and get yourself done the documents. Please go to the court, get your stand clear in the court of law, how the document is post-mortem by the senior advocates while appreciating the evidence or appreciating the documents or exhibiting the documents or denying to exhibit the documents. You will find that most of the new upcoming juniors are directly going to the sub-registrar's office, opening their office and practicing over there. That is good, you are getting money, but see, ultimately the correct avenue of getting the master in your conveyancing is you have to have the basic knowledge of the law, application of law, under which rule the document is framed. See, generally the Transfer of Property Act is the basic rule for the transfer of immovable property, and the other sections, the section 54 is regarding the sale, 55 is the roles and responsibilities of the buyer and seller. So whenever you are dealing with the conveyancing practice, at least minimum, you should have the legal knowledge of the particular section. When you are drafting for an agreement to sale, you have to understand the basic concept under the Indian Contract Act, how the contract forms and how and when it becomes a concluded contract. Because drafting a simple Visar Pauti MOU or agreement to sale is not simple thing. It is a base of all future legal battle in case of any dispute between the buyer and seller. Dear friends, I would like to also say that the section 58 under the Transfer of Property Act is denoting for the mortgages. Whenever we are dealing with various banks, we are in-panel lawyers for the various bankers. We have to have an execute mortgage deeds. The repercussion of mortgage deed, its enforceability under the Act, under the MCS Act, under the SARFAESI Act, needs to be checked when you are doing legal work for the bankers and you are certifying the title of the borrower to the land or the mortgager to the land. It is always necessary to see that how the title to the borrower came. Otherwise, in case of execution or implementation of a mortgage deed or the recovery of the money, many times it is seen that the title is defective. Sometimes we have generally our properties in India or Maharashtra or anywhere else are generally ancestral property we have herited from our forefathers. Now, in the cases of the conveyancing, when we deal with the mortgage, we have the undivided share. Can we take the undivided share for a mortgage and accept as a property? And can we enforce in the court of law when other co-owners are object for it? It happens in many cases that we take some portion of the land of particular person as a borrower in the mortgage, and then later on the entire family or the family members, either by connivance or by real intention, they object for enforceability of that. In that case, the bank is a loser, and being an advocate, we are also at fault that not following the proper procedure to get the mortgage deed executed. So long so far. Now, sale deed, what sale deed is doing, because most of the time, the all small stakeholders, the ordinary people, middle class, lower middle class, higher middle class, rich people, industrialists, even the corporate sectors, those who are dealing with the real estate project, when I work for these people, I find that I used to have a checklist first. Please get me this document. Because in getting this conveyance done, it is not only the 70th extract alone or the property card alone, or in case of in cantonment board, it is a GLR, we called it. So there are properties under the cantonment jurisdiction, the DEO, Defense Estate Officer, Defense Estate properties. Now that properties have old grants, they are restricted for transfer, they have B3 class. B3 class means the properties which belongs to the government and it is of defense owned property which cannot be transferred or it is to be sale unless and until there is a permission from the authorities. So also in case of the inconveniencing, we have the class 2 land, class 1 land, class 3 land. Now class 1 land is generally, we said it is a freehold land. Anybody can sell, purchase without the permission, without the restriction from the government authority. However, in case of a class 2 land, the class 2 lands are different categories of lands. That lands are Inam land, Watan land. These lands are government granted lands to the landless people under the Agricultural Selling and Holding Act 1961. So also there are class 3 land, that is a Devastan land, Masjid Inam land, which are not permitted to be transferred unless and until it is duly permitted. Now, in a recent time, the government of Maharashtra has issued one bill. Unfortunately, that bill has been withdrawn because the suggestion objection of the bill was up to 5th of June. Before that, due to some opposition of stakeholders, the government of Maharashtra has withdrawn that bill. Otherwise, it was planned that the Devastan Nam class 3 lands should be granted on class 1 lands. Now, another aspect under the conveyancing is not only the Transfer of Property Act, it involves a Registration Act, it involves a Stamp Act. Registration Act presupposes that every document under Section 70, a property worth ₹100 and above, a compulsorily registrable document. Section 18 connotes for the optional registration of the document, which does not mandate that document should be registered. So what type of document that? Will is optional. So far as gift deed is concerned, dear friends, we find that so many times the gift deeds are done within the family, within the blood relation, or sometimes out of the family, out of the charity, the gift deeds are done. Now in gift deed, one major aspect one has to be kept in mind. The gift deed of undivided share or undivided property is not permissible under the law. Many times we make a mistake of doing this. In number of High Court and Supreme Court judgment, it is said that undivided share of a gift is not legal, valid, and enforceable. Still, we venture to do that. So kindly remember and kindly go through the judgments of the High Courts and Supreme Courts on the point. The lease deed. Now, in conveyancing, a sale deed, gift deed, mortgage deed, lease deed, exchange deed are the multiple documents that we used to execute, used to prepare and used to do for our clients at their request while doing the lease deed. Now, lease of a property is not transfer of ownership, is not transfer of title, but it is transfer of interest in the property for a certain period with certain condition, reserving the premium or the rent reserved therein. Now, if the lease is to be done, there are parameters under the Bombay Stamp Act that Article 36 of the Bombay Stamp Act notifies the lease and the period of lease. The stamp duty under the Bombay Stamp Act for conveyancing under the lease for a lease period up to 5 years, the valuation is to be counted market value of the property, taken it to the consideration as a 10% of the market value. Say suppose the property value is 100, then for stamping purpose, the lease deed valuation for up to 5 years lease will be considered as a 10%, and accordingly the percentage as per the municipal limits or Gramin limit, the stamp duty is applicable. Up to 10 years, it is 25%. The lease period is more than 10 years, but up to 29 years, the market value is to be considered as 50% of the property and accordingly stamped. But when the lease deed is more than 29 years, it is a perpetual lease according to the law, and it is renewable at the option of either of the party if it is not agreed otherwise. Now, in lease deed, there are many instances now the townships are coming up where sometimes the property under the Maharashtra Ownership Flat Act or under the RERA 2016 under Section 13 agreement is required to be registered under Section 4 of the Maharashtra Ownership Flat Act. Agreement is compulsory registered. Same time, in leasehold properties like township, like take a case of the Lavasa Corporation, take a case of the Amanora Township, they are making a lease deed of 999 years, means a perpetual lease, wherein the ownership of the land remains with the company and the structure belongs to the lessee, and that lease is transferable, heritable at the option of the lessee. Now, considering the conveyancing part, dear friends, you need to have a checklist first while you are assessing the title of the vendor. Now, in case of a landed properties, take a case of an agricultural land or the land in municipal limit or Gauthan limit. Gauthan limit, we have the property card, PR card. In agricultural based or rural, we have the 712 extract. We need to check the title because the 712 extract is open on and from since 1929 onwards. Now in cities like Pune, where the or elsewhere in Maharashtra, the properties which are officially permitted for non-agricultural use, now double entry or double recording system of property card has been abolished. And now since on and from 2009 to 2020-21, the government of Maharashtra Land Revenue Department has opened new era that is a property card for land which are converted into a non-agricultural, and abolition or cancellation of the 712 extract. These things are going on, and you have to check because sometimes the cancellation of 712 extract and preparation of the property card may be sometimes not shown, and have a difficulty that we make a sale deed or conveyance deed or any transfer deed, and we find that end of the day the 712 extract is now closed and new property card is open, and then we need to correct the document. So in order to avoid, first of all, check the at least minimum 30 years revenue record to the flow of title. I say, or rather I insist to have the revenue record since 1929 or even before that. There was a Kadai Patrak prepared for the maintaining of the ownership, record of right, mutations and transfer of title or ownership. Now, in the current situation, the 712 extract, we see that initially our forefathers, we have the, we were not having the Hindu codified law until 17 June 1956. We have the Hindu codified law, the Hindu law on and from 17 June 1956. Before that, it was a customary law, just like Muslim law is a customary law because it is not a codified law. Now, in that situation, it was observed that the head of the family, Karta, or the eldest or person of the family used to be the person recorded on the 712 extract, and other people were not shown on the Satbara. Later on, it is found that the person or the eldest person or member of the karta of the family died, and after his demise, the property get transferred to his legal heirs without referring to his other brothers or sisters. In that case, the link of ownership, link of co-partnery get vanished, and then later on, sometimes the people used to transfer the property at their own without looking into the previous title owners or the successor, and then it comes the cases in the court of law that the share of a brother, share of a sister was bypassed, and the court, after having seen that the mutation entry was there and the name of the person was skipped while rewriting the 712 extract. In that case, even though you just really see the 712 extract and without going into the past record, your client may suffer a huge loss of title, loss of property, loss of money. So I suggest practicing in the field of conveyancing. It's not just see a single piece of paper of 712 extract or piece of paper of property card. Go for the mutation entries, trace it. Sometimes now the Maharashtra Consolidation and Fragmentation Act is there. The act was introduced, and thereafter the survey numbers of the land village were consolidated and assigned new block number or gut number, wherein it is most of the time it is found that the land is transferred to somebody's name, but the possession remains with the same person. And when later on it is found that when we are measuring the land or demarcating the land with the government land record department, it is found that the person whose name stands on the 712 extract is not actually in possession. In that case, I request and I suggest to all my budding lawyers or the all the lawyers that you please take out a consolidation scheme extract from the land record department and see which survey number and hissa numbers are assigned as a block number, and at the same time there are the procedures where the exchange of possession, exchange of money, exchange of compensation is done. That has to be seen. Otherwise, we may get the property and so many of boundary issues or so many of possession issues are there based on the Consolidation and Fragmentation Act. The possession never get transferred, but 712 extract. In a recent case, my client, we had fight for the case for 40 years. And after that, now the matter is remanded back to the lower court for the consolidation office for reconsider the consolidation scheme. Now 40 or 45 years of legal battle, and again remitting back the matter to the lower court will be the same procedure. Again, it will reach to the high court for another multiple years. So while you are making a conveyance, you need to know the actual law, the procedural part, the registration part, because unless you trace out the title, the legal title or conveyancing cannot be done properly, or otherwise it will open a floodgate for the litigation. In order to avoid all such litigations, it is advisable to the lawyers, when the clients are coming to you, please ensure that you have the proper checklist of the documents, checklist with the e-court cases. Then if it is in a corporate sector, kindly search for the ROC record, partnership record, LLP. If the LLP is there, the same thing, just like in a corporate sector, you find out the various court, district court, trial court, high court record, whether the pending litigations are going on, because under the Transfer of Property Act, list pendency provision is there applied. But in a recent High Court judgment, it is said that the Revenue Authority has to just only mention the case number and year of the case. That's it. No party's name should be recorded in other right column. So in that case, we should be very alert that is there any litigation going on? Is there any injunction order is passed? Because now we have the online e-court system, and we can easily understand and we can know the basic litigation part. So far, so long, the conveyancing part is concerned, just getting the draft done and get it registered under Section 17 of the Registration Act is not as simple as we think. Basically, we found that so many of registration office is overcrowded with the advocate's office, and generally, instead of advocate, non-advocates are also make drafting the conveyance deeds or other types of deeds and documents, which literally they don't know the legal avenues, whether the drafting is correct, whether the title is clearly sought out in order to verify the title. Now, public notice is there. Public notice is generally issued to make aware that the buyer be aware under Section 55 of the Transfer of Property Act. The duties are cast upon the sellers, buyers, that one should not take disadvantage. One should disclose them any infirmity in the title document. If at all there are any problems, the advocate should address to the seller or the buyer and make a requisition of that. If sometimes the seller is in a hurry to sell his property, purchaser is in a hurry to purchase the property, maybe purchaser is getting a best deal, maybe a seller is getting good money without any hassle. But I suggest to my all lawyers that even though clients are in hurry, don't be a scapegoat for your client, but be the protector of your client, that after getting the conveyance or before making a conveyance, a thorough checking of a title is most important. I'll tell you that in and around 2007 to 2008-9, I had an opportunity to work for one big real estate company, Bombay based, and the work was assigned from one solicitor firm from Delhi, and it was 2,000 acres of land. I really experienced a lot in that matter. Friends, in such 2,000 acres of land of due diligence, our team could have been only find that near about 500-acre plus land is a clear marketable title, and remaining land having a qualified title. Now, a qualified title means title having an infirmity. In that case, if you have any doubt, please reserve your point, please reserve your opinion, and say clearly to the client that, boss, this property is having this problem, please clear it. Otherwise, don't venture for purchase. Now, I would like to tell you that in many agricultural lands, we have the class 2 lands. The land acquired under the Bombay Tenancy under Section 32G, restriction under Section 43. So also under 32P, the lands are confiscated under Section 84C, and it is again reallocated to the other class of people. And that property is also subject to a condition that without the previous permission, land cannot be transferred. So you have to find that whether such land is having any restriction on transfer. We generally find that most of the time such restrictions are overlooked and people venture to buy such land, but their name would not be recorded to the property card. They cannot enjoy the property in full. Even though possession is with them, the title remains defective. A conveyance part under the Bombay Stamp Act. Now I'm referring Bombay Stamp Act because under the Article 25, A and B. A is relating to movable stamp duty applicable for the movable properties, that is 3%, and under Article 25B that relates to a immovable property, that falling various categories like municipal, Mumbai, Pune, metro cities, municipal corporation limit, and rural. Now, the Stamp Act is also one of the vital part in conveyancing, because how to assess the stamp for a particular document or particular nature of instrument. In such cases, the Bombay Stamp Act needs to be read thoroughly by the advocates and to conclude that which type of document needs a stamp duty and which type of documents need not require or minimum stamp duty. Now, in case of a release of ancestral property, under Article 52 of the Bombay Stamp Act, it requires the minimum stamp duty of rupees 500. In case of partition, the minimum, if it is relating to an agricultural land, the stamp duty is applicable 500 rupees. Now, government is also proposing that the registration fee should be waived off for documents of partition. That is in process. In case of the leave and license, because most of the junior advocates or upcoming budding lawyers are having such types of, though it is looks simple document, but it is a very vital document. The document of leave and license governs under Article 36A of the Bombay Stamp Act. Now, that aspect has to be dealt with because the document of leave and license for a period up to 5 years is chargeable based on the total collective collection of the rent per year with 5 years with interest on deposit. But if it exceeds 5 years, then it is treated as a lease. And accordingly, under Article 36, the stamp duty is applicable on such document based on the property valuation and percentage of the valuation. Now, in exchange deed, friends, the documents are, the properties are exchanged between the parties. Now, exchange deed, the quantum of stamp duty is on one property which having higher value and not for two properties. Means if one property is having value of 1 crore and other is 90 lakhs, the property of worth value 1 crore will be applicable for stamp duty and 90 lakh is not considered. So there will be a aspect. Now, in case of getting this title, again, I say, when exchange deed is done, it is done between two parties and document is of one only. Now, what is the procedure now? If you want to get the similar documents, the original document, under Article 27 of the Bombay Stamp Act, you can make duplicate. You have to pay the stamp duty. It will be original signature, original stamp, original registration number. Say, suppose if the original exchange deed is having number 1 of 2026, this duplicate will be bearing 2 of 26. But these both documents will be treated as an original, and in case of title or in case of dealing with various financial authorities or other government departments, these duplicate document is equally treated as an original and can be used without insisting the person holding the original document that it is misplaced or not misplaced, or it is not readily available for the perusal for the financial institute or the court purpose. Same is case with the partition deed. If you are doing the partition deed, make the, if there are 4 brothers or 2 brothers or 3 brothers, let's have number of copies according to the family. If there are 4 brothers, 1 will be the original document, 3 duplicate copy you can have. You can have original signature, photographs, and also the registration. So it will be a creation of original document ipso facto by operation of law. Dear friends, conveyancing, though it is apparently is easy because it is a copy paste matter, but I advise let's have your own drafting, assess the title of the property, same time make a requisition. I have an opportunity while working in around 2004 or 5 with big Bombay industrialist property at Dabhade, near about 30 plus acre, and my client was supposed to take, and I had an opportunity to interact and have an interaction with the Bombay-based solicitor firm. Even I would like to name that solicitor firm is the Solomon and Solomon, and I really appreciate the head of the solicitor firm, Mr. Solomon, was personally getting dictated to his PA, then that steno get the draft prepared with printout, and then he used to read and have his own mark on the draft. So generally, I advise to all the lawyers, all the advocates, budding advocates, upcoming advocates, have your own draft prepared, take a printout, read it again, see the corrections, whatever is the legal requirement in the document. देणारचं घेणार झालं, घेणारचं देणार झालं तर काय होतं याचा आपण कोर्टामध्ये जास्त अनुभव घेतो. एनी हाव, I say conveyancing is a very innovative field for the young lawyers and also the lawyers who are practicing in this field, because it is a type of a job that you get the good money. So, so also you create a good more litigation. Now, in order to avoid the litigation, your drafting should be such that it should fit it to the legal framework or applicable laws. Now, under the Watan land, the there are provisions, the class 1, class 2, the Mahar Watan land, or the Deshpande, Kulkarni, Patil Watan, Ramoshi Watan. These Watan lands require to be check thoroughly, understand thoroughly. If you'd like to have the session to be heard, my YouTube lecture on the Watan land is available. So you can have that lecture to be heard. Friends, it is also a matter that while drafting any draft, take a case, you are drafting for the Visar Pod, you are drafting for agreement to sale, you are drafting for some other documentation. The intention of the parties to be looked into, the consideration, what the property is transferred, whether the property is properly demarcated, whether it is identified by four corners, four boundaries. If the property is not identified by four boundaries, and then there is a dispute regarding encroachment or identification of a property, it will be a big legal battle. In a recent time, I had a great experience while working with one Bombay-based solicitor firm of a great industrialist, and the property was a Pune-based amenity plot. So we had, you will be surprised to hear that we had 38 times draft were revised, and one long marathon meeting since morning 10 to evening 10 with a span of half an hour just for breakfast. Then we finally finalized the draft of agreement to sell. So you understand, 38 times we reviewed the draft means every time the words, commas, the condition precedent, condition CPs are finalized. Then after condition precedent, then obligations, everything was discussed, and really we were exhausted by such. But later on, we found that that series of discussion on the drafts was really good, because we have got a very great experience that we should not leave a single thing in the draft that we will be debatable, arguable in the court of law if in case of a dispute. So conveyancing part is also one of the basic and crucial part that cannot be overlooked, that cannot be bypassed, that cannot be just passing reference or anything that will lead to means TK. We got the document done, registered. It's not the case. In a recent time also, I would like to have share with you an experience that one of the royal family, I am dealing with them since being their lawyer. A property in Pune was in cantonment limit. Now, in the cantonment limit, defense estate office is there, defense properties are there, old run properties are there. There are the properties called B3 class properties. B3 class properties are basically from the government land, the defense land, wherein permission is mandatory. So the question comes when I have prepared the draft and had been to the sub-registrar's office, it was refused. Refused means, no, this is a defense property, it is a GLR property. I said, okay, where it finds that it is a defense property? They said, no, this is a GLR, and you need to take a permission from the defense. I said, no, it is a private property. It belongs to the royal family. They transferred to a company, their own company. They prepared the bungalows, and they returned some bungalows, and now they are selling one of the bungalows. Then there was a huge discussion, huge debate on that. Then I personally met two officers and then have a very harmonious discussion without fighting or arguing with the authority. I make them aware that, look, this is a clear property, and the B3, you said the B3 class property, it needs to refer that particular GLR incorporated in the list. And then I took out the list. I shown to her. Then she satisfied, yes, sir, it was my mistake. I just randomly thought it is a government property. So sometimes the officer is also not aware. Sometimes we lawyer are also not aware of the legal position, because so many of time there are government GRs issued. There are you will be surprised that the Indian Registration Act also have the Indian registration rules, and which is not easily available or in market. That books are with the registration office. They hardly give us or understand it. But the procedure under the Registration Act is also important. When somebody refuses your document, that this document is opposed to public policy or opposed to a certain law, there is a section 18C recently amended, just like I introduced you regarding the cantonment properties or defense estate properties. The section 18C is introduced in the Registration Act, that no such document shall be registered by the registration authority unless and until the permission from the concerned department is procured. Now, we should be well versed with the Registration Act, Bombay Stamp Act, the Transfer of Property Act, so also other with the tenancy law, the land laws, because as we are dealing with the movable properties, it's not just the registration and Bombay Stamp Act or just Transfer of Property Act will be dealt with. It is a vast ocean that out of which you have to take out the true and correct opinion and get the perfect property transfer of ownership and title to your client. Otherwise, your client will be at losing end for his money, for his legal battle, for his mental and physical health, financial stress. So wherever, friends, matter of conveyancing is concerned, don't take it so lightly. Ask for the minimum last 30 years track record of the land revenue, the zone certificate, DP plan, RP plan. Sometimes the property we propose to buy is covered under the RP road, DP road, and we never know. And when we go for the planning for the construction of houses or building, we found that the property is affected by reservation. Now, why the zone certificate is also important, why the DP plan or RP plan is important, because certain properties are reserved by the government or the local authorities for public purposes, garden, playground, school, or any type of riverbed, mala. Even you are buying the property near about the coastal area. There is a CRZ, CRZ 123. CRZ 123 is what? 1, 2, and 3 is restriction on the use of the land and construction over that particular parameter. Say from the high tide level, 500 meters is non-developable zone. Now these restrictions are created by in a recent time, because so many you find that so many of the hotels or resorts are already built over there, but those having a previous mandated, previous committed development, it cannot be hampered. But new development at coastal area is also a very concern, that you should check the CRZ zone, and then whether you are eligible to construct or you are eligible to not construct, that has to be looked into. Dear friends, while dealing with the conveyancing and practicing as since last 30 plus years in this field of judicial and being an advocate, up to 2012, I had been regularly in the court, but after 2012, the work load of the construction project and the development real estate is huge. Having just the ma'am has rightly said that I'm a team of at least 22 people plus with me working for the real estate. Also the legal team, having the litigation team practicing the court. At least 10 to 12 persons are in the court. When dealing with the convincing part, I always keep it in mind, when this document, if challenged, if get in toss for the legal battle, either by the person executing the document or person having got executed the document, or the legal heirs of the family, or the other successor in title of the property, what will be the fate of that document, should be always bear in mind that when your document goes to the court of law, that should stand strongly and in favor of the purchaser, that his title become or to be a sound, perfect and legal. Now, most of the time, it is found that the people are not issuing public notices. Public notices is that buyer be aware. Now, public at large should be known that some property is going to be transferred somebody to someone else, and it is known to public. So it is a part of due diligence, and due diligence is most vital in financial aspects of the financial institutions, banks, corporate sector. When they are developing the properties, they have to have apply for the APF, the financial CF, construction finance, or the project to be approved for the good that anybody can buy the property and the banker can assist them because the title is clear. Even under the RERA, now the title to be kept definite and perfect is cast upon the owner or the promoter or co-promoter that the title of the property should be clear. In a RERA 2016 law and the Maharera authority have number of times and casually or regularly issuing a resolutions or issuing a circulars directing how the RERA should be implemented. So those who are practicing in the conveyancing field and those who are in the field of construction projects should also bear in mind there is a format A under the RERA wherein negotiable and non-negotiable clauses are there, wherein negotiable clauses where you can add, delete, or you can make supplementary, but non-negotiable clause cannot be diluted. And if it is diluted, the RERA authority have power to reject your application for the registration. So also in RERA, there is a legal title format A and flop title. So now that also is become very complicated nowadays, because when I heard that from my client's part, your title report, now being in field of the real estate and the conveyancing since last more than 30 years, find that a title report is rejected. Rejected for what? When I inquire it, it is surprised to know that the Maharera authority have engaged the law officers. That law officers are having experience of 2 or 3 years in the court, and they are engaged or assigned the work of assessing the title report issued by the senior advocates or the advocates standing in the field. And even for small things, commas and full stop and apostrophes and slash and obliques are being looked after by these officers. In fact, they should see that what is a flop title and whether it is correctly written down and whether it is correctly got it by the developer to develop the property. But unfortunately, the there's a very bad thing is that the officers who are sitting over there are very unexperienced, and we have a lot of, means the clients have a lot of headache, a lot of delay in the getting the registration certificate. As you are aware that unless and until the registration project is registered with the Maharera, the builder is not entitled to accept the booking amount. So the convincing at the threshold, at the particular point of time is easy. Yes, when you are master, then it is easy. When you are not master, we are not aware of the laws, not aware of the circulars, not aware of the notifications, and not aware of the litigation part that may culminate ultimately in case of any dispute. So convincing is matter of practice, reading law, understanding law, application of proper law, and getting it done. It's not mere registration. Registration is a formality. It is a procedural law. You have to have the substantive law to be bear in mind. What is the substantive law? The substantive law which defines the legal right, enforceable right, the authority in the matter, and the procedural law is just getting the document and CPC is there, then the Registration Act is there. These are procedural law. But substantive law means Transfer of Property Act, Bombay Stamp Act. These are the vital laws that needs to be understood thoroughly by the parties, by the advocates, and then accordingly should be uh, guided to our client that he should not be put to any loss. I think so. I have concluded my session. Any question and answers, please?
Yes, sir. Thank you so much, sir. I have muted all the participants. Let me quickly unmute them. Dear participants, if there are any questions, we'll be having the last 10-15 minutes for Q&A. Please keep your questions ready. Yes, I request the participants one by one who have raised their hands to posit the question to sir, please.
So, ma'am, good
Yes.
afternoon, sir. May I ask a question?
Yeah, please.
So, I just want to know what would be the standard fees to be asked for the conveyance deed, basically.
See, it depends upon the individual. Even there was Bar Council of Maharashtra has issued one guideline for the fees, but see that that is not applicable and that is not being followed. But generally, see, if you are a senior, one thing sometimes the people come and say the advocate charge 5,000, 10,000. Why you are charging 50,000? So
Yes.
our caliber, our expertise to charge the fees. There's no watertight rule or format that how to charge, because basically the type of client come to you and type of services you render, type of I said now, then you have to have the file done with rigorously investigated, and that you can charge accordingly. See, suppose now I'm a junior of 3, 5 years or 4 years, I may charge 5,000. But same time, being an senior advocate like me, then I charge for 1 lakh, 2 lakh, 3 lakh, 5 lakh. It is immaterial.
Okay, sir. Thank you.
Sir, I have a question. In Pune and PCMC area, there are so many agriculture land
Yeah.
in which is like builder have applied